SHRM got hit with an $11.5 million verdict in an employment lawsuit. So what does that mean for you? Well, SHRM is the Society for Human Resource Management, the world's largest HR organization. They call themselves the trusted authority in all things work. But SHRM's also an employer, and SHRM let an employee go over 5 years ago, and that employee had filed a charge and eventually a lawsuit claiming racial discrimination and retaliation. That case went all the way through the courts and finally went to trial last week in federal court in Colorado. And in just that week, a jury just took a few hours to deliberate and awarded that former employee $11.5 million against SHRM. Now, last year, when the judge had actually sent this case to trial, I made a video about lessons for all employers. I'll link it here. Because in addition to it being SHRM, so it's really notable, because SHRM puts out best practices and certifications for HR professionals about how to handle the very things at issue in this lawsuit, like performance management, investigations, termination. And there's a lot of lessons for everyone to learn, including SHRM. But now that the lawsuit's over, I'll give another breakdown of what happened, what really stood out to me, and where things can go from here. I created this to guide through some of the lessons and takeaways from the SHRM lawsuit, because there have literally been thousands of pages, deposition testimony, all sorts of filings. But it can be helpful to point out some of the things that really stuck out. Because this isn't just a case of like, oh gosh, can you believe SHRM did that? Because that is a very real reaction that people are having, but also at every organization to understand how much it matters, how you communicate and the decisions you make, and how there are gaps that everyone can learn from this lawsuit. Now, this case has gotten a lot of attention because it's SHRM, and now this is the actual jury verdict form. They found $1.5 million in compensatory damages, things like pain and suffering to make the plaintiff whole, but then $10 million on top of it as punitive damages. Now, this is a verdict that what happened, so this was Friday night, December 5th, it came out. That doesn't mean that the plaintiff left with like a large check for $11.5 million. What happens now is that SHRM can, and they've said that they will, appeal this to the highest courts in the land. The next court here is the Federal Court of Appeals for the 10th Circuit. So that makes up Colorado and some other kind of westernist states. So SHRM will have to file the appeal. And so what often happens is defendants in these lawsuits, they have to put a bond together, very similar. There's like, if you've heard of bail bond, there's also corporate judgment bonds. And so they'll put that in. And so the plaintiff's not likely to see money until the appeals are finally exhausted. So yes, there's a jury verdict, but it doesn't stop here because the next level is the Court of Appeals. The level above that is the United States Supreme Court. And so they'd have to choose to take up this case. But we can expect there to be a lot of litigation after this, especially looking at SHRM's statement about the verdict, which we'll look at in a bit. So when juries decide how to award a verdict, it can be really helpful to start with this, because juries, right before they go to deliberate, have a whole jury instructions. This is what the court, meaning the federal judge, reads to them to explain how to think about whether to find for the plaintiff, the person, the former employee who brought the lawsuit, or for SHRM, the Society for Human Resource Management, and what sort of things to think about. So one of the things is, in this case, the plaintiff has said she was terminated from employment for racial discrimination and retaliation. SHRM says that's not the case. It was because she missed 2 deadlines on these projects. She was an instructional designer. So the question a lot of people may have is, okay, if it's she said, they said, how does the jury figure it out? And in these cases, they often have to decide who they'll believe. In part, whether they believe SHRM's reason for termination, or if they think that it's false. So some people may have the question of, okay, how does this jury decide whether they think that reason is false or not? So the court in the jury instructions also gives examples of what can make someone doubt an employer's reason for an employment decision. I'll show you these examples in the next slide, but sometimes this shows things like patterns that don't seem to make sense or gaps. And so when jurors see things that don't make sense, that's when they might start doubting and saying, okay, do we really believe what the employer's saying is this is the real reason or the only reason? So here, and you'll see, I've redacted this. There's the case site. Don't have to redact this, but I've done it just to focus more on the lessons and takeaways rather than the people involved. So that's why you'll see it. Yellow is my adding. But some of this is, okay, that the plaintiff can show and the jury could believe that SHRM's reason, these missed deadlines, aren't the actual true reason for termination for different things. Like, did SHRM treat someone else differently, especially someone of a different race? Because plaintiff is Black Egyptian, and so did they treat employees of other race differently than her? Whether there's subjective criteria, like, oh, I just don't like it, like not objective, but things like that. how an employer previously treated an employee, like what's the history of how they've treated them. If they think that one of the employer's witnesses lack credibility. So if different people from SHRM came in, and in this trial, plenty of people from SHRM came in, including SHRM's CEO, which is super unusual. In employment cases, there's often a lot of motions and fighting that employers never want their CEO to actually be deposed or come to trial to give testimony. SHRM actually fought this itself just a couple of weeks ago in a separate case that they had with a former consultant, where that consultant had said that they were going to depose SHRM CEO. SHRM asked the court to block that deposition. The parties ended up settling the lawsuit the day before the court hearing, where the judge would have heard arguments about whether to make SHRM CEO testify or not. So suffice to say, that's much more of a common example of fighting to keep a CEO out of testimony. Here, SHRM brought their CEO to testify. In looking at the testimony, I'd seen the rough draft of the transcript of that day of the trial testimony. It was really short. He talked to the plaintiff one time, but largely seemed to show that the CEO showing like, I care about employees. That's what it seemed like. But anyway, some of these reasons as well, for some reason, the jury was like, I don't believe that. Or if there's a short period of time between when someone complains of discrimination or retaliation and the actions that took. That's a very notable one in this case. Also, procedural irregularities. So if SHRM had a policy or practice and they acted differently than that. Or if an employer failed to fully investigate those complaints. Again, here it's discrimination, which is the plaintiff saying, hey, I was treated differently because of my race. And then retaliation, which is I was also treated differently because I spoke up about my discrimination. Because in June of 2020, the plaintiff complained of discrimination. She was then talking to HR, an investigator from HR, and then also claimed retaliation. She actually sent an email to 3 executives at SHRM on August 19th of 2020. And was terminated from employment just within about a week and a half after that. And so that short period of time plays in here, and also some questions about whether the investigation was also full. And more, if the employer wasn't uniformly enforcing its own rules, this is where it's really important that if employers have rules, what actually happens to them in practice, or also if there's some sort of evidence that a reason for termination is false, implausible, or these things. And so a takeaway is, looking through all of this is often with leaders, you may say this is what the decision is, and this is what it is, like it's because she missed deadlines. But in this case in particular, it's an example of how that decision was made was seen very differently by the employee and by others, including a colleague at work, than those leaders said it was. And so it's really important as a leader to think, when you're making a decision, how might this be seen by others? What would an employee say? Like if you were going to tell them that, what might they feel is unfair? How have others been treated? And if they've been treated differently, were their circumstances really differently? Or would others outside the organization, like future jury, possibly think otherwise? And so it's really important to think of not just have your kind of leadership goggles on and focusing on it, but also to think of how it would appear to that individual who's the subject of the decision, but also anyone outside your organization. So the jury did hear examples of some of these. And so a lot of times in lawsuits, you may hear people saying like, okay, if there's a lawsuit, the lawyers will handle it, blah, 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 blah. But people that have been involved in employment litigation can see everything from sitting for a deposition to preparing to scouring through your emails. That whole process is a lot more impactful than just a lawsuit. It's going through the way you sent communications, decisions that you made, and really having to explain and justify things well after the fact. And so here's some of the questions that's really important to think of. Again, looking at what happened in this lawsuit, but putting this in the context of any decision, especially that a manager or those in HR would make it work. And I say here, this doesn't mean to say, okay, put things in writing. Well, just don't put it in writing then. Like that's a response I know some people would say, like, okay, then we shouldn't be writing things down. It's really thinking about whether it's verbal, written, just the way you act to someone, especially when you're in a position of leadership or HR. It really has an impact on people, and it can last well after the fact. The first question, and this really came into play in this lawsuit, is, are we treating this person differently? And not just, do I think, the person making the decision, do I think we're treating someone differently? But that person, would they think that? Or someone wholly unrelated to our organization, how would they see it? And the reason this came into play is that the plaintiff in this lawsuit, the former employee, she's a Black Egyptian employee who's a senior instructional designer. She created courses that SHRM would sell to the public. And she had a white colleague, another senior instructional designer. They had the same boss, and she actually filed a sworn declaration. This was a really key piece of evidence throughout the lawsuit. This, in different parts, talked about how that colleague said that she'd internally, to different leaders at SHRM, to HR, that she'd raised her own concerns, that the plaintiff was being treated differently based on her race. But SHRM had said that the plaintiff was terminated from employment. The sole reason for that was missing two deadlines, two August 31st, 2020 deadlines. Well, this white colleague also had an August 31st deadline, and she didn't make it. And during the trial, she testified that she actually missed it on purpose. And I haven't seen further explanation of why she did that, but this plaintiff had done the same thing, and the plaintiff was terminated from employment. The white colleague was not, and she said that she'd missed other deadlines, didn't have negative consequences. Now, SHRM has, again, denied any discrimination or retaliation against the plaintiff, but they've said these situations are different, that the two can't be compared. But the question isn't just SHRM, because as the jury looks at it, they have to decide, who do we believe? Do we believe SHRM saying it was solely due to a deadline? And as they look at this white colleague, is it different enough? So these are some of the considerations that likely went through the jury as they were deciding it. This was a really, really, again, key piece of evidence. Now, part that also came into play during the lawsuit is that some aspects of this colleague's sworn declaration, that in one in particular, she talked about a conversation she'd had with the senior leader at SHRM and described it of making complaints about their boss. Well, SHRM, long after the fact, they found a recording of that conversation. And SHRM said, I haven't listened to it, I haven't seen it on the docket, but SHRM said she actually said differently in that conversation that she said in her declaration. And so this is where people may say, okay, what if it's she said, they said, like the colleague says this in her sworn declaration, but SHRM has shown otherwise for certain aspects. Who do they believe? Well, that comes down to the jury deciding who they decide to believe, who they find most credible. And these are real considerations that the jury likely had to make. But in this situation, SHRM has said, again, these two colleagues, they missed deadlines, but they're different. But other people, certainly including the plaintiff, felt that they were more alike than different, but also the jury, this likely came into consideration for them. Now, another consideration is what happened when the complaints were actually made, because in this case, the plaintiff had made a complaint of discrimination in June 2020, that in particular, that her boss had discriminated against her based on her race. Now, in this, SHRM had assigned an investigator, and we'll talk about that in a minute, but when someone is involved at work, like a manager in particular, and someone's raised a concern about you, naturally it can feel incredibly personal, hard. Oh my gosh, this person's saying this, especially if you don't agree with it whatsoever. But it's really important that organizations work with managers and other team members to understand when someone raises a concern about you, what that plays out, and how important it is that you listen to it and consider it, and not just immediately, get frustrated or try to react otherwise, because that can turn something into retaliation, which is something that the plaintiff has claimed in this case. And so a couple pieces of evidence that came in. One was deposition testimony from SHRM's own investigator, the SHRM employee that was in charge of the investigation. Now, when he talked about a conversation he'd had with actually not just the plaintiff's manager, but the plaintiff's manager's manager, like the two bosses above, that person had said she wasn't going to be under attack by the plaintiff. And that was in the notes that he'd had. And so again, this aspect of under attack, and what does that actually mean? Is that how you feel because someone raised concerns about you? Because that is a very human reaction, but especially in the workplace, it's important to make sure that you take the response in and not just be defensive. Likewise, the plaintiff's manager, she actually had testified of, okay, well, I felt like there were rumors spreading around. I felt like I was being harassed and bullied because the plaintiff made these allegations. And the allegations she's talking about is racial discrimination. And so it is super important at organizations that when an employee raises a concern about discrimination, there may be situations where you find that they're unfounded, you don't agree with that. But understanding how it can feel to that employee to raise those concerns in all of the emotions they likely have when they raise that, and how important it is that the people that are the subject of those complaints, including if it's their manager, they understand the importance of responding it, and that there is not even the appearance of retaliation. But in this case, the plaintiff had said, after she raised that claim, that she was retaliated against by her boss. So in it, there's also a quote, Johnny C. Taylor, the CEO of SHRM, just this summer in USA Today, he actually had said the quote, when leadership chooses retaliation over reflection, It not only stifles open communication, but also damages trust and morale across the organization. So he was talking about when people raise concerns and how important it is to really reflect on that, not retaliate against employees. So another is talking about in some of the considerations of jurors and how they decide whether to believe the employer or not is looking at investigation procedures. Now, SHRM, in their best practices for investigation, they give out all sorts of guides. But one of the depositions taken during the discovery process for this case was the individual who, at the time of all of these events, was the chief human resources officer at SHRM. He's no longer there. And in it, one of the questions from plaintiff's counsel is, okay, did SHRM have procedures for investigating complaints? And the CHRO said not written ones. The attorney said, do you have unwritten procedures? He said no. And so understanding not every organization is going to have specified procedures of how to do an investigation, but it can be really helpful to have an idea of exactly what to do and say rather than just leaving it up to general expectations. And so as the jury thought through it, again, not being in the jury deliberation room, but it's certainly possible here that if the jury had heard this testimony, again, we haven't seen everything that the jury heard as part of the trial, but the testimony about what SHRM tells the public to do and what they have themselves, that can certainly play a part of whether they felt like the investigation was full, because that was another aspect of trying to decide if it was a full investigation. So here, SHRM's saying we didn't have any formal written or unwritten procedures. The question is, but they said we have best practices. So what were the best practices that you'd expect SHRM employees to follow? This CHRO, this is still him testifying, and he had said, okay, to treat participants respectfully, to solicit information confidentially as much as possible, okay? And the plaintiff's attorney said, okay, would you also expect that the investigator would document information they collected as part of the investigation? And the answer is yes. But again, when you say things like we rely on best practices, that can sound ideal until you're actually in the middle of it and you're the person investigating, especially if you don't have as much experience. And so here, while SHRM has cited best practices and things, the deposition testimony and things that likely came out at trial showed those procedures and expectations weren't always followed through. Because so SHRM had its investigation. It appointed an individual who was SHRM's manager of employee experience. And this was an employee who reported to the CHRO, but so his job was in this case, to investigate the plaintiff's case. And so in it, some of the question was documentation, and the plaintiff's counsel saying, where is this documentation, or could there have been more documentation than you did in this case? Because some of the conversations, a lot of this is, I don't recall, that happened a lot in his deposition in particular, this investigator. And so the plaintiff's counsel had said, would a best practice have been documenting more thoroughly than you did? And throughout his deposition, there's a lot of answers that have these kind of dashes in it. But he did say, this investigator, that with hindsight, more could have been done in that area to document things. And there's other areas that even in the sworn testimony, so this same investigator had said on the team, the manager who was being accused of discrimination and retaliation by the plaintiff, she had 4 direct reports. 2 were white and 2 were black. Now, this investigator, when he was going through these concerns, he found out that not only did the plaintiff have concerns about race discrimination, and she'd raised these directly, but that the other black colleague on the team, that she purportedly had concerns about racial discrimination as well. But that investigator acknowledged he, for whatever reason, and he couldn't remember why, that other black colleague's concerns weren't investigated to the same degree that the plaintiffs were. He actually didn't speak with that other black colleague. He spoke with there were 4 direct reports, he spoke with 3 of them, but not the other black colleague on the team. And so in thinking about a full investigation, again, the jury is looking at this, and as they're looking at SHRM and, okay, what does that look like from a best practice perspective and having a thorough investigation, it's certainly possible that the jury could have looked at this and thought, okay, not interviewing someone that seems like they'd be really relevant, does that constitute a full investigation or not? So another is, with investigations, plenty of organizations all the time say we actually haven't had investigations before, so what do we do? And that's what happened in this case, because this manager of employee experience at SHRM, when asked how many employment discrimination complaints he'd investigated in his whole career, he said it was only this one, just the plaintiffs. He'd never handled a discrimination complaint before. And he was asked to handle this by the chief human resources officer, who said he had, in his deposition testimony, he's sworn, the CHRO, that he didn't have concerns about this investigator because he'd seen him work before. But when asked if this investigator, if he didn't have experience and that it was unclear, he couldn't remember if he knew how many investigations that manager had investigated before like this, which the answer was none. The question is, what about training? Because that manager of employee experience, he had his SHRM CP certification, which is more of a general HR certification. It includes investigations as part of it, but it's more general. So the plaintiff's counsel had asked, were there any training or certifications he had conducting investigations? Do you know if he did? This is a CHRO, Chief Human Resources Officer of SHRM, who said, I don't know if he had any of these specialized training and investigations. Plaintiff's counsel, was there any specialized knowledge about race discrimination or retaliation law? Again, I don't know. But also to each of those questions, when asked by plaintiff's counsel, does it matter to you if he did or not? The Chief Human Resources Officer said no. And so, again, in the depositions, there's all sorts of testimony that comes in. There's pages and pages and pages. And not all of that makes the exact trial. But this is the type of information that when you read this, and plenty of people in HR might read this and say, how could you not care? And those are questions that if the jury had heard this as well, they may be having the very same. And so this is some of the deposition, sworn testimony, that when you read this back, especially when you have an investigator over a race discrimination and then retaliation complaint that hasn't had experience in it and not knowledge, because he says he didn't have any specialized training aside from the SHRM internal general training, that he didn't have that. And so again, looking at this, especially being SHRM the leader in best practices, it's certainly surprising to a lot that would read these deposition testimonies, but added up, especially when you could look at things of a colleague saying she'd been treated differently, she hadn't been terminated by deadlines. It just goes to what the jury has been told. You have to decide whether you believe SHRM's reason or not. And all of this kind of can come into play. And so other questions are neutrality. So you have an investigator. So regardless of experience and training, this person's in charge of the investigation. So what does that look like? In one of the questions, the plaintiff's counsel had asked this HR employee experience manager was like, do you think it's important to maintain neutrality? And when you look at SHRM best practices about investigations, through and through, you'll see how much they say it is so important to have actual neutrality and also appear neutral. Because if you're investigating something, you certainly want anyone on any side think that you're favoring one side or another. And I've seen some questions come about of like, could he be neutral at all if he worked for SHRM? But plenty of times organizations do have internal investigators. And personally, I've seen internal investigators that have been fantastic at really being neutral, hearing things. And I've seen resolutions that worked out to the complaining employee's favor and action taken on those. So it's absolutely possible. But that neutrality aspect is so important. And so in any organization, just being mindful of that. And sometimes you don't know, like plaintiffs, you don't know whether someone's neutral or not. But some of the things that came out in discovery in particular was that at the same time that this plaintiff, she'd complained of discrimination, this investigation was going on. Well, she was also emailing with leaders and having emails about performance. And in one in particular, for example, she'd emailed three different leaders at points in time, or she'd had conversations and talked about things like discrimination and retaliation. And at different times, this investigator was not only investigating her concerns, but also giving, as he put it, guidance to people, including the plaintiff's boss, on communication. And there were some questions in the testimony about, were you ghostwriting emails? And there was a lot of discussion about the term ghostwriting. But even as this investigator described it as giving guidance, it can create, at the very least, a perception of not exactly neutrality if you're not only looking into someone's concerns, but you're guiding other people on how to communicate with them throughout the process on things like the concerns that they're raising. And so in one case, there was a SHRM senior leader who was like 3 levels above the plaintiff, the boss's boss. And when he'd gotten a communication, he forwarded it to another leader and had said, hey, you should have this investigator get involved to get the right language on the table to correct her, the plaintiff, quickly, or to support an eventual case for termination. And, again, while if there's a termination, it is absolutely important to look at the language that's been used. When you see someone that's a senior level leader, especially when there have been communications about discrimination, retaliation. And one of the talks is to get this investigator involved with language about supporting this potential eventual case for termination as one of really two options. That raised a lot of concern. So that's one of the areas that's really stuck out a lot. And so it's incredibly important, not just that that person doing the investigation is neutral, but the others understand what their role is. And it's that it's really clear and that they have those so that when people are looking back on it, whether it's someone looking back on the docket or the jury actually looking at these things, that it feels neutral as well. Because after the fact, I can only imagine what that was like in discovery when it came about that this investigator had also been involved in these communications. I imagine that the plaintiff's counsel was very, very surprised to see those. But we will, we do not know because that's between them and their counsel. But another is one of the questions, and this was in that employee experience manager during his deposition was asked, okay, well, do you think that's fair to the plaintiff that you have this role? And he had said, well, that could be for someone else to answer. And when the plaintiff's attorney said, I guess the jury will answer it, he was like, yes. And this is part of his deposition that was nearly 2.5 years before the actual trial. And notably, this employee experience manager, sometimes people take a deposition often, but then they also show up to the trial, whether they show up in person or they give testimony by video. That happens sometimes. This employee experience manager, for whatever reason, he actually was not personally in trial. And so his deposition, a lot of it actually got read aloud. So pieces of this talking about his involvement, his investigation, his guidance, those type of things were actually read aloud to the jury. So these are some of the things the jury was considering when they were deciding, okay, do we believe SHRM's response in what they're saying she was terminated for? Or do we think maybe this investigation wasn't full enough? Or that this employee was treated differently? And do we believe SHRM or not? So these are all things that came into play for the jury. So when the jury was deliberating, what can happen is, so on a Friday morning, midway through the morning, their jury was deliberated. So last Friday, first the plaintiff gave their closing argument, plaintiff's lawyers, then the SHRM's lawyers, they gave their closing argument, and the plaintiff's lawyer gave like a little short one after. That's often what happens. And then the jury gets to deliberate. So they go back into a private room, and they're talking about this. And what they can do is ask questions. And that's, of course, to the lawyers in particular, it's a huge signal. So the lawyers had to stick around the courtroom and stay just within 10 minutes or so around the courtroom in case there was a verdict or in case there were questions. And the jury did have a question. So just a few hours after they'd started deliberating, the jury's question was twofold. One was, who receives punitive damages? And then, is there a formula or max value for punitive damages? Now, you can only imagine what it was like for the lawyers in that courtroom, because if you're SHRM, you can imagine, okay, the question on who receives punitive damages, actually that was a really interesting one, because the answer here is punitive damages go to the plaintiff. The plaintiff likely has to pay her lawyers out of a judgment. Eventually, that's often how it works in these cases, because in plaintiff side litigation, not always, but frequently, it's what's called contingent. And so if you've ever heard the commercials of if you don't pay unless you get paid or things like that, what happens is if you have a judgment, like if you settle or if you get a trial judgment, then your lawyers take a piece of that. And so lawyers are incentivized to make sure they have good cases, to try their best in a case, but a plaintiff generally isn't taking a lot of money out of pocket, like sometimes court costs and things like that. But that's often how these things work. And so punitive damages go to the plaintiff, and then again, between the plaintiff and their lawyer often, how that works. But who receives punitive damages? But then that question of, is there a max value for punitive damages? You can imagine the lawyers to that, especially if the lawyers for SHRM, their throats or parts probably dropped to their stomach to hear that, because that's certainly an indication that they were going to fine for the plaintiff, and they were wondering how much would they give. And eventually that's the case, because they did issue the verdict for $1.5 million to the plaintiff and $10 million in compensatory. So the total of the $11.5 million verdict, which we'll see what happens through appeals. And one thing that's got some notice is before the trial, when things played out, was motions in limine. And so motions in limine is a kind of a legal saying of what parties can argue or introduce evidence of at trial and what they can't. And the lawyers for each side, often before the trial, will go to the judge to hash these things out so that they're not bringing them up, during the middle of trial, and certainly not in front of a jury. In one of the multiple things that SHRM asked to limit at trial, one thing was that they didn't want plaintiffs' lawyers from introducing evidence of or arguments about SHRM as a quote unquote model employer. And what they said by that is that this would hold SHRM to a higher standard than any other employer facing similar claims, and then confuse the issues, mislead jury. So that's not fair. Now, the judge had declined to bar this whatsoever, because while this doesn't necessarily, and this is the whole idea behind this, is SHRM is a best practices, HR and investigation, should they know better? And a lot of people in comments have said absolutely they should have. And looking at the jury's verdict, it seems like they likely seem to have felt the same way. But while SHRM's business does not change the legal standard, how it can come into play is a couple ways. Like maybe it's in punitive damages that they think, okay, especially they treated the plaintiff with reckless disregard because they knew better and they still did those things. It's possible in that, but the legal standard doesn't change. But it's not just an aspect. Like this trial doesn't just live in a vacuum, and that's what can often be really important, is that when companies get sued or organizations get sued, and a lot of lawsuits won't get this level of publicity. This is SHRM, and so that's a huge reason why you're seeing this. But there is, the court of public opinion, whether that's other colleagues that see this or others, if this does get media attention, that really look and they have their own thoughts. And so SHRM's then chief human resources officer, when he was getting deposed, he was actually asked, do you think SHRM has a responsibility to be a model workplace given its mission? And he had said, over some standard objections from his counsel, like, yes, I do. And so this is one of the reasons that SHRM likely filed this motion in limine, because from the questions and the depositions, they could tell the direction that plaintiff's counsel was likely going. But you hear the individual that was head of SHRM's human resources saying they do have this responsibility. And so a lot of people I've seen, again, in the reactions to the verdict, seem to agree. So immediately after the verdict, SHRM issued this statement. And in this, they talk about how they disagree, but some of this is interesting, is this saying this claim has no merit, none. This isn't the facts, the law, the truth, any of this. And what you don't see in this statement are some of the recognitions of the things that individuals said, like the CHRO, of at times, I would have expected the investigator, if he heard about a retaliation complaint, to look into that. I would have expected if he heard of concerns of discrimination of another colleague, he would have looked into that. And the deposition then of that investigator showing otherwise. And so while no organization is perfect, in this, there's always opportunities to use it as a lesson. And again, this is a court case. So rarely in a court case are you going to see a defendant show any inkling of, okay, maybe we will be responsible in here. But it's not just a court case. SHRM is still an organization that has a ton of members that are looking to it for their direction. And so that's why, in response to this, again, you've seen the reactions. The reactions are definitely split. There's a lot more in the comments. This is just on LinkedIn. There have been comments aplenty with people's reactions to this. But again, while there's the jury verdict in that, there's also this court of public opinion, including the opinion of its members. And SHRM is a national organization. It also has more localized chapters that often have a lot of volunteers, that have a lot of resources. And so it's hard to look to a jury verdict and people trying to understand, how do we react to this? Because again, a lot of times you do see this, and it's not just in a court case, but sometimes you see a leader make a decision. Like sometimes it's a project at work and it doesn't work out, and people may have spent a lot of time on it. The organization spent money on it. And sometimes that project goes away and there's no conversation about what happened, any lessons learned, or it's like, we're just going to sunset it and you never hear about anything else again. And so it really is important in the workplace to think about, how can we use things as a lesson? Because any of us, as we look back on things that we do at work, outside of work, a lot of times we look back and would do things differently. But there's a lot of questions now, not just what SHRM is going to do with, again, they're saying that they're going to keep appealing the verdict. Also, the question is the trust that they have with members, and that overall for organizations, when something goes wrong at work, or you look at decisions that could have been handled differently, how can we actually learn from this? And so 3 bullet points I have in here and I say this is for HR teams, but nothing, whether it's how you treat people, is not just an HR issue. Oftentimes I think HR can drive these conversations. They often see the most need for it. And I intentionally say HR, not just legal. I was a lawyer and I was in HR. Lawyer's job is absolutely to protect an organization, but you also don't protect an organization by doing the bare minimum and treating people terribly. And in HR, I think you really have an opportunity to proactively impact not just that people feel like they're treated fairly so they don't bring a lawsuit, but that people feel like they're treated fairly so that they want to show up to work. They want to perform. They want to refer other people that they like to work there. They want to grow. All of that ties in with each other. And so in here are just three questions that I think it can be helpful to start with HR teams to have these conversations and then say, okay, but how do we get buy-in from other leaders? And the first is, do we have processes that are clear, consistent, and human? Like they really reflect reality. And then also, do people know how to follow them in practice? Because just having a policy and never following it or a process, it's really not going to serve anybody. And so making sure people know how to follow them. Then when you make decisions, are they thought out? Are we taking that pause to think about, okay, do they feel fair to these people involved? Or pausing, okay, if I'm going to terminate this person's employment, who could they point to of a similar situation? And do we think that was similar? What were the true differences? And how do you really gut check yourselves on that? Because so they're not just treating one person in a way without consideration of what's happened before with them and others. And then the last is, how would someone outside our organization view it? Like, and also our documentation and how we communicate. Because sometimes when I looked at some of the communications on the docket, you just read it and you see the plaintiff sometimes asking for help on things and being told her tone is concerning by things. And that ended up being a lot of conversation in some of these depositions. And so just taking that pause to think, a lot of communications you make, other people, people outside, jurors are never going to be looking at it. Thankfully, most of us go through work day in and day out and are, spending our days in lawsuits. But it is important to think about how communications can look for each other. And so I think this is a conversation that's especially helpful to start with HR teams and then think about how you have this with managers. As I started Manager Method, we've designed it to not just have training, because you see in this, for example, like this investigator, he's like, I had my SHRM certification, I saw this training. But you didn't hear him say, like, okay, and then I had it, and we role played of how we would handle different investigations, and we talked about it and things. And so that's why, as I started Manager Method, we have trainings and things like that. But what we also have are toolkits for organizations to have cohorts to come together and talk about it, including things like this. Like, what would you do if someone raised a concern it had to do with you? Or what if someone told you it was just a rumor? How do you address that? It's really important to have those real conversations. And again, this isn't just to avoid a lawsuit. Certainly that's ideal. Nobody wants to be involved in that. But work is so much more than that. And there's so many benefits to people's work and also their lives outside of work. I truly believe that. And so having those conversations and building them up and giving that opportunity to practice, I think are real conversations. So, I've been tracking this lawsuit a lot. I've spent a lot of time in the dockets and whatnot. So hopefully this breakdown is helpful of some of what we saw. But I'll be having an upcoming blog and a video there just this week on questions to ask before you make employment decisions. So expanding this a little bit that I really think, again, are very important, not just to avoid lawsuits, but to really positively impact the way people work and how they feel about their work. So feel free to look at that. And I hope this has been helpful.